Recently, I was reading a case, Zhang versus Apple and Samsung, and it's a subject matter eligibility case. It caused kind of a stir because it extended the sort of Alice 101 analysis beyond software into a optical invention. It was about cameras and sort of lenses on the camera in order to increase the effectiveness of the camera for taking pictures. But I'm actually not going to talk about that case right now because I think when I was reading the case, it really drove home to me, there's actually a bigger problem than just that case. And that is the patent office's guidelines are really, really obsolete. And that's kind of a concern to me. So I was reading this case and I was looking at it and thought, this is not the way the court's evaluating this. This doesn't really match what the patent office does during prosecution. And I looked at the patent office subject matter eligibility page to see, hey, maybe I misremembered something, looked at the MPEP, and no, they haven't actually issued any new guidance since 2019. And that wouldn't be such a big problem if nothing significant had happened in the past 2 years. But the problem is that isn't the case. So obviously, right, there's you and Zhang. You also wouldn't know about American Axle versus Needco, which the Supreme Court may take up. They've asked for the solicitor's input, which is always a sign they might, be granting cert. And just in general, the more cases and more developments that aren't there, the more arrows you don't have in your quiver during prosecution. And we're not actually just talking about cases being stale. There seems to be a genuine divergence between how 101 is treated in the courts and how it's done on the patent office. So I mentioned you and Zhang versus Apple. It didn't match, right? That's what kind of got me looking back at it. And I'll just give you one example of that kind of divergence, which is in you and Zhang, the abstract idea was taking two pictures, which may be at different exposures, and using one picture to enhance the other. Now, if I'm at the patent office, right, using their subject matter eligibility framework, I think that there's a good chance that wouldn't be treated as an abstract idea at all, because it's not a mathematical concept, it's not a method of organizing human activities, and it's not a mental process. And even if it was, so even if that was treated as an abstract idea, the fact that the claims purported to improve the functioning of the digital camera did nothing to save them at the federal circuit. Whereas in the patent office, improving a computer or other technology is generally sufficient to establish a practical application and therefore patent eligibility. Another example is Cleveland Clinic versus True Health. Again, something that you wouldn't necessarily see, but in that case, the Federal Circuit explicitly declined to follow example 29 of the Patent Office's eligibility examples. But if you're looking at the Patent Office's materials, you'd have no way of knowing that. And that's a problem. And it's a problem for a couple of reasons. One is you can't just say, oh, I'm only going to follow the Federal Circuit, so I'm going to ignore the Patent Office, because you might say you're going to just follow the Federal Circuit, but the Patent Office, the examiners, they still follow the MPEP. And, you can obviously make your case to an examiner, right? I've had some people tell me that they think the examiners don't listen to anything if it's not in the MPEP. Well, that's not true. And I think that's wrong. I guess there's there's not a million, but there's thousands of examiners. Maybe there are some who are like that. I haven't run into them, but they may exist. Okay, fine. But in general, I think you can do it. But even with an examiner who is willing to look at your arguments that aren't based on the MPEP, you have to do two things with it, right? Because examiners, they're going to be going with their own framework. But also, if you're going to say, oh, well, here's this new thing, you have to both show how that new thing is good for you, but you also have to explain it to them, right? Because they've been trained on the MPEP. They've been trained on the subject matter eligibility framework. They haven't been trained on whatever new thing you're trying to cite to them. So you have two things, right? You have to explain the rules, then apply the rules. Whereas if you're talking about something that's in the MPEP or in the guidance, all you have to do is explain it. So that it just makes it harder, even if you're in a case where examiners are willing to look at it. And that's, that makes things difficult. So what can you do, right? What can you do about this? Well, one approach is to make arguments using both the Patent Office's guidelines as well as more recent court decisions. So you won't be vulnerable or as vulnerable to attacks based on relying on PTO guidance that a court might not follow later. An example of this is a response that was filed on August 12th, 2020 on 14-834-642. And I think that response, and there's going to be a link maybe here or above me. Anyway, there's going to be a link somewhere to a place where you can get a PDF of it. But I think that response did a good job, not just of saying, hey, here's some new cases, and they cited some cases from 2020, but it also said, here is how we also work under the PTO's guidance. So they were able to get through, and they did it kind of in a parallel approach, which is, in my opinion, not ideal because, you know, you'd rather not have to do two things, right? Where you could do one, but I think it's a good way of dealing with the just this obsolescence and the fact that, you know, when you're prosecuting a patent, you have to consider both what the patent examiner is looking at, as well as the fact that that may not be the be all and end all for the courts. The other thing that I would say on this is I think you're going to have to really be very cognizant, or maybe not have to, but I think it would make a lot of sense to be very cognizant of what examiners have done in their cases, right? So going back to the MPEP, you know, that at least gave you a framework. People were familiar with it. You could sort of know what's going on. The examiners knew what was going on, right? So I'd have an interview with an examiner. I'd say, hey, examiner, what do you think of this argument? What do you think of that argument? And they'd tell you because they're familiar with it. And, you know, it was a lot easier to move forward because they were familiar with it. You weren't asking them to kind of do something from square one. And I think, you know, going forward, as if you do kind of work with that parallel approach that I was describing, trying to connect that approach to things the examiner has done already will make things a lot easier for you. Because again, you'll be in an interview and you can present an argument they know and they can kind of be familiar with rather than something that they're just hearing for the first time out of you. For example, one thing that you can do, right, there's knowledge management systems. And I've talked in some of my other videos, you know, I've got essentially like a little note of here are things like that I've done in the past that I can use. I also have a tool that I put together called the Arguminer software, which you can enter in search strings to try and find things that have worked in similar cases. So for example, the office action I mentioned previously, the way I found that was I did a word search to find office action responses that overcame 101 rejections and used the case CardioNet, which is a 2020 case, is the search parameter. And I think going forward, having some kind of support for yourself, either internal knowledge management, external tools like the Arguminer software, both, I think will be increasingly important because yes, you know, you can rely on what the examiners are doing, but I think we need to recognize the fact that what the examiners are doing is kind of diverging from the courts. And if we just look at one, we're really only looking at half the picture. So really, that's kind of what I wanted to talk through today. It is something that troubles me a little, reading through sort of some of these recent cases, seeing how the Federal Circuit really operates, I think really drives home that the materials that you're seeing at the Patent Office really are a little bit obsolete, but there are approaches, there are ways to handle it. And you know, you can still get through with patents using both the Patent Office guidelines as well as the more recent case law. So in any case, I hope everyone watching this has good luck and is able to be very successful with their patents and is able to navigate this somewhat more complicated than I think it needs to be landscape of Section 101. Thank you so much.